Welcome everybody, I'm Chris Miller. I am a legacy wealth strategist and I've been in practice for over 25 years. My clients learn how to create an income they'll never outlive. And no one on my watch has lost a dime. What I show my clients how to do is to protect their assets from long-term care, nursing home costs, probate, and the Great Recession. But today, I want to share with you my Living Trust workshop. I literally have been presenting this for over 25 years, and I want you to be empowered by all of this information that I have here to share with you. So I'm going to share with you some insights on how to protect your assets. Now, when you distribute your estate, a living trust is not a conversation about the end of life. A living trust is a living document that helps you protect your assets while you are alive too. So we're going to talk about how to wrap up those assets in protection and protect your assets from any kind of probate, conservatorship, powers of attorney. So let's begin. Now, how do you avoid probate? What's probate? Probate's courts, courts take attorneys, and attorneys take money. They take 5 to 25% of your estate, depending on how long your estate goes through probate. Now, how do living trusts work? When you set up a living trust, you simply transfer the title of all the assets you wish to place in the trust from you as an individual to you yourself, trustee of the trust. It's that easy, right? Well, living trusts have been around for a long time. There's an old saying, I'm certain you've heard it before, you can't take it with you. The reason why is, it usually goes before you do. Now that's not very funny for people that remember 2008. And that's what I show my clients, how to protect not only their assets at the end of the life, but during their life. What happens after your death? Fortunately, there are strategies that will enable you to completely avoid probate. Let's start with the basics. What is a strategy? What is an estate? An estate is simply all the assets you've accumulated during your lifetime. Stocks, bonds, business interests, basically everything you own. So, let's follow a typical estate through probate. Let's take the Andersons. Now, the Andersons left their family with a sizable estate, and their estate is going to be tied up in court. That's right. They have to hire an attorney, and they have to go through the time, the cost, and the delay to go through that probate process. Now, probate is really not necessary. And do you know that living trusts, that's one of the secrets that I talk about in my book. It's not really a secret. It's been around since the Middle Ages, but people don't talk about it. Now, I'm sure you've seen a lot of celebrities. In fact, you probably heard of Marilyn Monroe. Marilyn Monroe obviously didn't do any estate plan. When she passed away, she had $1.8 million. It took them 18 years to settle her estate. Guess how much was left? Somewhere $100,000 and up, somewhere in that vicinity. It happens to everybody that goes through probate. Look at Whitney Houston, Michael Jackson. We can go on down the line and make the list. Now, you also have another challenges at the time of this video, estate tax. That estate tax can go up to as high as 55%, depending on what year and where you're at when you pass away. So not only do you want to protect your estate from probate, if your estate is over the estate tax threshold, you want to avoid those nasty estate tax. There are a couple of notable exceptions to these. The one is the unlimited marital deduction, which just merely means that the transfer between the spouses allows you to pass that wealth, but upon the death of both spouses, then you're going to be vulnerable to the estate tax if you haven't done the proper planning. Now, in 2017, the time of this video, estate tax is 5.49. They're, thinking about getting rid of it. Whether it comes or goes, you need to be aware of this because every 4 years they could be changing this laws. Be mindful of your estate and make sure that your documents are going to protect you from probate, conservatorship, and estate tax. Okay, now, there are 3 ways that you can distribute your estate. 1, do nothing. 2, set up a will, and 3, set up a living trust. So let's just take these one at a time. The first, do nothing, is obviously dying intestate. When you die intestate, the probate court distributes your estate according to the laws of the state. Rarely takes into concern how you may have wanted your affairs settled. Without proper planning, your estate is likely to be reduced significantly upon your death, and your heirs will be tied up with a long probate process. They'll be tied up from anywhere from 1 to 2 years or more in that nasty estate process. And they'll lose a considerable amount of money during this time. Who knows? Your estate could end up with a sibling. You may not want to have that. Now, you'll be vulnerable to all the fees imposed upon your death. Vulnerable to all the fees and taxes that are imposed upon your death, and guaranteed a trip through probate courts, attorneys, and fees. What about joint tenancy? A lot of people think, well, if my husband is on my deed, or put my sons and daughters on my bank account, something happens and they're on there. No, don't do that. It makes you vulnerable to all creditor claims. In other words, all joint tenants are vulnerable to creditor claims. Very dangerous way to leave your estate. Plus, you lose what's called the stepped-up tax basis, which is a tax advantage for you having the living trust. Now, those joint tenancy considerations can also relate to families from second marriages. So it's very important that you look at the titles of your beneficiaries. Check your 401k and your IRAs, because you may have your first spouse on there and you may be in a second or third marriage. A lot of times people forget that their beneficiaries need to be checked on in your qualified accounts. Very important to be looking at. Now, the second technique you can use to control the distribution of your estate is to set up a will. What is a will? A will is simply a list of instructions that tell the judge exactly how you would like to have your estate distributed if the probate court upholds your will. And there are a number of factors you should consider when deciding whether or not to use a will, because you'll be vulnerable. It's a ticket to probate. And you'll have to go, or your heirs will have to go to court, hire an attorney. It is a nightmare. You do not want to go to probate. Not only financially, emotionally, it wrecks you. It pulls you apart. So it's a very vulnerable way to leave your estate. Now, a living trust will literally act as a prenuptial agreement, meaning that if I get married to someone else after I got divorced or my husband passed away, I literally can protect my assets from second marriages. So it's a very good technique. As long as I don't put my new spouse on all those assets, I literally can keep my estate to my sets of kids from my first marriage. Now, the third and final technique I want to share with you is the living trust. And I'm really proud to say I've been doing this over 25 years, and I have prepared over thousands. I stopped counting after 6 of living trusts, and thank God I've never had one problem. They work just fine. The beautiful thing about the living trust, it's a legal entity that's created to own, manage, and administer your assets. So what it does is you literally change the title of all the assets that you want to be protected from probate. And by that title change, your living trust will reflect the title of the trust on all your assets. That keeps you out of court. That keeps you out of probate, and that keeps you out of all those expenses. Now, another beautiful thing about probate is it protects you from conservatorship. So, if I become incapacitated, God forbid, and I don't have someone appointed, I'll literally end up in a living probate. That's right. You'll go to court while you're alive if you don't have someone that loves you, that'll be able to be there to take care of you if something happens. Another benefit that our living trust has is guardianship. Here's something that a lot of people don't think about. Mom and dad go out to dinner. We're living in a 911 world, and God forbid they don't come back. Who's going to take care of the kids? This is something you really seriously need to look at. Not saying it's going to happen, but make sure that you have the documents so that you are protected. Now, when you set up a living trust, all those assets go in the trust, and you maintain full control over all the assets you place in the trust. Sounds nice, doesn't it? Well, let's look at how the living trusts work. So, when you fund your trust, it's a very simple way that we literally have developed to show our clients how to do it simply by transferring all the assets you wish to protect from probate and conservatorship in the name of your trust. Why don't more people have living trusts? Do you know that living trusts have been around for centuries? They are nothing new. And as I said before, that's one of the secrets that I have in my book, Ready for Pre-Retirement. But it's not a secret. It's just that people aren't talking about it. So that's why we're here with you today talking about it, getting the information out so people can understand how they work. So let's just take an example. What is an AB trust? An AB trust is a way that you literally can use the marital deduction, and by using both of those unified credits, you can, at this time of this video, pass up to $11 million without any estate tax. And yes, there are ways, if you have more than $11 million, to protect your estate. But we're not going to go into that conversation here. We're just giving you the high-level view on how you can protect your hard-earned assets. Now, let's take some case studies. Let's take Mr. and Mrs. Smith. Mr. and Mrs. Smith have a nice estate. They have 2 kids. One's in high school, one's in college, 2 boys. Say they have $200,000, a house, and they have a lot of assets of artwork and things in the house. They want to make sure that goes to their kids. So what happens is Mr. and Mrs. Smith set up the revocable living trust. They place those assets within the trust. Upon the death of the first spouse, the second spouse receives all the assets in the trust. Upon this passing of the second spouse, all those assets go to their children without probate, without conservatorship, without attorneys, without me. I'm not an attorney. I am, in California, a legal document assistant. I prepare living trusts for attorneys, for banks, for people, and like I said, I've prepared thousands of them. You will not need me. We are going to empower you so you know exactly what to do. It's very simple. And then, literally, using this trust will allow Mr. and Mrs. Smith to save at least 5 to 25% of their estate, $30,000 or more, depending on how greedy the courts get with the Smiths. It's a beautiful way for them to leave their estate to their kids without any problems. Now, let's take another case study. Mr. and Mrs. Jones. Mr. and Mrs. Jones have $11 million. So not only do they want to avoid probate, they want to avoid that nasty estate tax. So they're going to put those assets in the trust, called funding your trust, putting it in the name of the trust. Now, upon the death of the first spouse, 2 separate trusts are created. The assets of the B trust are the deceased spouse is transferred to the B trust, and the assets of the living spouse are transferred to the A trust. That creates 2 taxable entities, each of which is entitled to use the exemption, depending on what year you pass away. Right now, it would allow Mr. and Mrs. Jones to not only avoid probate, conservatorship, guardianship, estate tax. It's fabulous. And using this revocable living AB trust will allow them to avoid the nasty estate tax. And this is going to literally save them an estimated $707,000 in probate fees and at least $1.3 million in estate tax. So you can see the advantage right here and now, how wonderful this trust is. Okay, one final case. Mr. Goodman, he's a widower. He has no children, so he's going to leave his estate to his children of his lifelong friends. Now, he's kind of multi-managing this, and he wants to make sure that these kids go to college. So he's going to customize his trust and say that John has to go to college and get his degree, so he only gets a third distributed, and he actually controls the distribution of his estate and literally can detail exactly how he would like to have it distributed. Plus, he can leave whatever else he wants to his charity. So these are beautiful ways. Using this living trust for Mr. Goodman allowed him to not only avoid probate, conservatorship, all the fees and taxes. It is literally going to save him an estimated 5 to 25% of his estate. All right. Few other techniques that you want to make sure you have included in your trust package is a pour-over will. A pour-over will is kind of like a catch-all, covers all your jewelry, furnishing, automobiles, and includes it in the trust. That's part of the trust package. Your power of attorney for financial. This is why I say this is a living document. This is not just an end-of-the-life document. If I break my leg skiing, God forbid, who's going to pay my bills? My power of attorney will take care of all my financial matters till I get well again. Same with the health care power of attorney. Your power of attorney for health care is very important, and it's very important that you have a copy of that with your doctor ahead of time on file, on record, so your family doesn't go into chaos trying to help you. Very important things that you need to have inside of your estate plan. Now, where do we go from here? I know I just downloaded a whole lot of information, and I'm sharing this with you because I want you to be empowered like I am. I want you to learn about protecting your assets. I want you to learn about growing your assets without risk. I want you to learn about making sure you're comfortable in your golden years, that you're protected from long-term care. So today we talked about the living trust. And I'm going to invite you to reach out to me. All the details will be part of this program. You will see a way that you will be able to contact our office and get a 20-minute financial fitness strategy session. You know, there's an old saying by Oliver Wendell Holmes who says, "Put not your trust in money, but put your money in trust." Now, I think he has a really good idea here. Not only do we want to put our money in trust, we want to put a bottom on our money, and we want to make sure that our money outlives us. I want to thank you for joining me, and I will look forward to seeing you on your financial fitness strategy session.